Lesson 48, the struggle for civil rights and equal protection. Let's take a look at the background of this struggle. Let's go all the way back to the Civil War, where African Americans routinely faced discrimination, as defined as unfair treatment based upon prejudice against a certain group. Black codes, Jim Crow laws, grandfather clauses, poll taxes, all of these were used to discriminate against African Americans. The term black codes is associated with legislation passed by Southern states after the Civil War in an attempt to control the labor, movements, and activities of African Americans. There were signs posted in towns to keep blacks from integrating with whites. These signs read, "If black, stay back." Some examples of Jim Crow laws are the segregation of public schools, public places, and public transportation, and the segregation of restrooms and restaurants for whites and blacks. The U.S. military was also segregated. Grandfather clauses originated in southern states after the Civil War, which created new restrictions on voter registration. They allowed men to vote based upon having their ancestors who had the right to vote before the Civil War. This was a way the South had to limit black voting. Poll taxes were paid as a prerequisite for voting. They were widely used in combination with other measures to bar blacks and poor whites from voter registration and voting. Now, legalizing segregation through the Supreme Court. The South routinely practiced segregation, which is the social separation of the races. Supreme Court upheld the constitutionality of segregation in the landmark case Plessy versus Ferguson in 1896. This was the Supreme Court case that made it legal for states to separate the races. The Supreme Court established the principle separate but equal in this case. They ruled that separate but equal did not violate the Equal Protection Clause of the 14th Amendment as long as the segregated facilities were equal. What was this case, Plessy versus Ferguson, 1896? Plessy really did not look like this, by the way, in the picture to the right. We're in Louisiana, the East Louisiana Railroad Company. They had a law that had a separate car bill in 1890. It separated passengers based upon their race. Passengers were required to sit in the appropriate areas or face a $25 fine or a 20-day jail sentence. Black nurses attending white children were permitted to ride in the white compartments, however. Homer Plessy, a shoemaker, was recruited by the French word, the Comité des Citoyens, prominent mixed-race men who were considered free people of color before the Civil War. They wanted to challenge the separate car law in order to halt the growth of these Jim Crow laws. Again, Jim Crow, segregation. Just kind of equate segregation with Jim Crow. Homer Plessy was Creole, which was 7/8 white, 1/8 black. He was octoroon. The committee thought his light complexion would show the arbitrariness of the law, and that Plessy would make a more sympathetic figure to white people. Plessy boarded the whites-only railroad car. He told the conductor that he was black. He actually had to tell the conductor, "Oh, by the way, I'm a black man." He refused to move when the conductor told him that he could not stay in the car. He was arrested. There's a landmark at Press Street Railroad Yards, site of the arrest of Homer Adolph Plessy in Louisiana today. Plessy wanted to get arrested so that he could challenge the Louisiana law. Remember, laws have to be challenged in court, and the Supreme Court has to agree to hear the law on appeal. Plessy's lawyers appealed the conviction, claiming the Louisiana law was unconstitutional, was a violation of the Equal Protection Clause of the 14th Amendment. We know what is that clause, right? No state shall deny to any person within its jurisdiction the equal protection of the laws. It also contains the Privileges and Immunities Clause and the Due Process Clause, all in this very important amendment to our Constitution, the 14th Amendment. Is separating the races denying citizens equal protection of the laws? That was the question that the Supreme Court had to consider. And the Supreme Court ruled no. Segregation is not a violation of a citizen's equal protection guarantee. Remember, this is 1896. The court ruled 7-1 against Plessy. There must have been a vacancy on the court at this time of the ruling in 1896, because we know there are 9 Supreme Court justices on the court. They said that the equal protection guarantee of the 14th Amendment only requires equal access to the same facilities. Equal access. Equal access. Hence the term separate but equal. We consider the underlying fallacy of the plaintiff's argument to consist in the assumption that the enforced separation of the two races stamps the colored race with a badge of inferiority. If the civil and political rights of both races be equal, one cannot be inferior to the other civilly or politically. So in the majority opinion, the Supreme Court is basically saying that just because the facilities are segregated by race, it does not mean that one race is inferior to the other race. Separate but equal does not imply racial inferiority. That's right. There's no implication. It's blatant. The lone dissenter was Justice John Harlan, a visionary, I guess, on the court in 1896, because he wrote this in his minority opinion. Our Constitution is colorblind and neither knows nor tolerates classes among citizens. In respect of civil rights, all citizens are equal before the law. Good for Mr. Harlan. He was the lone dissenter in Plessy versus Ferguson. So what this ruling did, it basically legalized segregation throughout the South. For the next 50 years, separate but equal was the law of the land. Question: why doesn't this gentleman, drinking at the colored water fountain, just walk over to the white water fountain and drink from it? Notice oftentimes the facilities that are separate are not equal. Well, he could just walk over and drink from that water fountain, but then he would be arrested. It's against the law. That's the point. It would take many many more years for African Americans to secure their civil rights. And we define civil rights as the rights of full citizenship and equality under the law. The rights of full citizenship and equality under the law. The National Association for the Advancement of Colored People, known as the NAACP in this acronym, was formed in 1909, and they wanted to work through the courts to challenge laws that denied African Americans their rights. The NAACP worked through the courts. The National Urban League formed in 1910, a year later, and they worked hard to improve opportunities for African Americans in the cities. Both of these organizations are still around today and still working hard today on the behalf of African Americans and other people of color. These groups built a civil rights movement. We shall overcome. Civil rights movement. The movement made an important gain in 1948 when President Harry Truman signed an executive order to end segregation in the armed forces. We talked about this executive order in an earlier lesson, but it wasn't until 1954, Brown versus Board of Education of Topeka, Kansas, where the separate but equal doctrine was shot down by the Supreme Court. We'll pick up lesson 49 with that landmark case, Brown versus Board of Education.